Very well, we now continue with public business, and the first item is the draft Commissioner for Children and Young People Amendment of Lord Jersey regulations lodged by the Chief Minister. The main responder is the Chair of the Children, Education and Home Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Commissioner for Children and Young People Amendment of Lord Jersey Regulations 2000. The states make these regulations under Articles 3, 3 and 30 of the Commissioner for Children and Young People Jersey Law 2019.
Chief Minister.
Thank you, sir. The Commissioner for Children and Young People Law contains regulation-making powers which allow the Chief Minister and the President of the Scrutiny Liaison Committee to agree and propose amendments to the existing appointment process for the Commissioner. Accordingly, the President of the Scrutiny Liaison Committee and I have worked together on two proposed amendments to the 2019 law, which are set out in these draft regulations. These proposed amendments are quite rightly being put before the Assembly for consideration, and we hope approval prior to the commencement of the recruitment of the next Children's Commissioner. One of the proposed amendments is to reduce the term of office for the Commissioner from 8 to 6 years. This would align with the recommendation made in the 2019 report of the Independent Jersey Care Inquiry Panel. This was the panel's 2-year follow-up review, which told us that a change was necessary to ensure that the Commissioner is able to sustain both their independence and, importantly, the public perception of that independence. The panel's view in 2019 was that the longer length of tenure made it difficult to sustain this independence, both in practice and perception. This proposed reduction in tenure from 8 to 6 years would also make the length of tenure for Jersey's Commissioner consistent with those of commissioners in the UK. The other proposed amendment is in these draft regulations is to remove the prohibition on the appointment of certain persons to the office of Commissioner. These persons are the Acting Commissioner for Children and Young People, any former Acting Commissioner, and a member of the Commissioner's staff. As the law currently stands, the Acting Commissioner and any other staff working for the Commissioner would be disqualified on the basis that they're employed by the State's Employment Board. The original rationale for a wide scope of exclusions was to deliver added trust and confidence in the office, given the remit of the Commissioner's functions. The extent of the existing disqualifications means that recruitment to the post from within the island is unlikely. However, not allowing the Acting Commissioner or any serving member of Commission staff to even be considered for the role seems overly strict and excessive. Indeed, we consider this to be largely unintended consequence of the initial legislation that wasn't considered at that time. The proposed amendment therefore puts forward a more proportionate set of arrangements that is sensitive to the important public perception of independence, whilst also offering those working in the Children's Commissioner's office an opportunity to be included and compete in the existing rigorous and independent appointments process. Sir, I move the principles.
Are the principles seconded? Does any member wish to speak on the principles? Deputy Mezek.
Thank you, sir. Can I speak in support of this proposition and provide perhaps a little bit more background on top of what the Chief Minister's already provided in an attempt to be helpful? I was consulted on this in my role as President of the Scrutiny Liaison Committee because the Children's Commissioner law does state in it that the appointment of a Commissioner for Children would be made by a joint proposition between the Chief Minister and the President of the Scrutiny Liaison Committee. I was Minister for Children and brought the original legislation forward, and I had no idea that that would one day include me. And at the time, I was referring to the President of the Scrutiny Liaison Committee, who now is the other side of that. But that safeguard was deliberately put in that law to make sure that this doesn't become a politically partisan appointment, and that there are safeguards in place to make sure that there can be a perception of independence for whoever ends up in that role. When we brought that law forward, it was the first time that we'd passed legislation to formally create a Children's Commissioner and their office in law. And so when we put those safeguards in to ensure that the person who would become Children's Commissioner was somebody we could have trust in, would be independent, and crucially, sir, would not be somebody who there would be worrying perceptions of being tied too close to the events that were spoken of in the Independent Jersey Care Inquiry, and more broadly, what they spoke about in their recommendation 7 on the Jersey Way, that it would be too far enough removed from that so that we would have trust in the Office of the Children's Commissioner to be able to do their job of promoting and defending children's rights, and importantly, being able to speak truth to power and be, from time to time, shining a light on things that some people in our community may find very inconvenient, for which there's clearly a public interest and the interest of children to do so. It was not foreseen at that time that because of a technicality that would include prohibiting people who work in the Office of the Children's Commissioner from applying to become Commissioner. The prohibition of people working for the States of Jersey from applying was right at the time, and it's still right to this day. But it was made at a time where this office hadn't yet been formally established in this way, and so to have considered it now, it strikes me as appropriate in principle to allow people who work in that office, who I would say already have the independence by the fact they work in that office, rather than properly directly for government, to at least have the opportunity to be able to apply for that role, knowing that all of the other safeguards exist in that process still unchanged from this. And of course, it was during my time as Minister for Children when the Care Inquiry came back for its 2-year review, where it was able to look at the foundation of this office at that point, and they made their recommendation that the term limit should be decreased slightly for all the reasons that the Chief Minister has just given. So it would seem an apposite time to implement that change as well. So I'm very comfortable with this law change and will be supporting it.
Thank you very much indeed, Deputy. Deputy Catherine Curtis.
Thank you, sir. The Children Education and Home Affairs Scrutiny Panel supports this proposition. I refer members to our comments paper. As can be seen on the last page of our comments paper, we did ask the Chief Minister to respond to 2 points of concern. Firstly, to explore more fully the possibility of a pan-island commissioner for future times. And secondly, that consideration be given to the residency rules so that applicants from outside the island are not put off from applying. So could the Chief Minister advise the extent to which these points were considered and whether they will be considered further in the future? But the panel does support the proposition.
Does any other member wish to speak on the principles? Deputy Rob Ward.
Thank you, sir. Actually, I'm not entirely sure that I agree with the principle that's been put forward here, and I'll try and explain why. And I'm not entirely sure whether to support this. And the reason is that I do support the reduction in term. That was a recommendation made, and that's not a problem, I think, at all. But I think there is a level of independence from having somebody who has no connection at all with government that is specifically useful for this role. This is an extremely important role, and it is still, I would say, a new role. It's the next iteration of the Children's Commissioner, and it was a very difficult time during COVID. There was an enormous amount going on, and we were very grateful for some of the input, some of which was very difficult for us to listen to about our actions. in this island. And I say our actions because we're all part of this island. And so we take collective responsibility for this island. And there was just something in the back of my mind, and it's nice there's a genuine open debate here about, and we've talked about this, and I speak for that reason, that the unintended consequence that was mentioned before may have a significant use. Because if you are going to, and somebody said, tell truth to power, you need to have the confidence that there is no way in which you can be linked previously or have, I don't know what the words are for once, sir, but there's an issue here that I can't vocalise entirely. And I think it is because that word independence means something. It means away from an organisation to talk about that organisation with total impunity. And I think any organisation that you have been part of is very difficult to move away from and have that independence. And if you're sat there, so if members are sat there thinking, I'm thinking out loud, yes, absolutely I am, because there is something I can't quite get right in my mind about this. And so I'm unsure, and I think we need to think very, very, very carefully before we accept this and make this change. I did chair the panel, and we did an enormous amount of work on the Kerr inquiry, some really difficult work as well, and I'm grateful to all the members who were part of that panel. And I recognise the challenge that Kerr inquiry leaves us and continues to leave us. There are still unsolved problems. There is still an issue over legacy issues that have not been addressed successfully, I firmly believe. And the Children's Commissioner will have to take those issues on, or will see the fallout from those issues. And so therefore a level of independence perhaps beyond the others is going to be quite important. So sir, those are my concerns. Others members may be able to vocalise things better than me. For once, sir, I'm genuinely unsure, and I'll be honest about it. Thank you, sir.
Very much, Deputy. Deputy Scott.
Thank you, sir. I just wanted to, what I had to say is somewhat along the lines of what Deputy Rob Ward was saying, and I can see some reasons and some good points that are being addressed in terms of this proposed regulations, but I remain somewhat uncomfortable about this concept of independence whilst you have members of these independent bodies who are being essentially employed by the State's Employment Board. And in particular, and perhaps the Chief Minister could answer this question to me, the question I have is who is really within government responsible for the budget, and in terms of giving the grants and how that plays out in terms of independence. It's something that I have raised in connection with the Chief Statistician and the budget that is part of the strategic, the SPPP department, whatever that acronym really stands for, which I constantly get confused about. But I would be appreciative of some more information there. Thank you.
Very much. Does any other member wish to speak on the principles? No other member wishes to speak on the principles? And I close the debate and call upon the Chief Minister to respond.
Thank you, sir, and I thank those members who've contributed to this debate. If I may just begin with Deputy Scott, who raises an interesting point about budgets and independence. Well, my first thought, sir, was to think of the non-ministerial bodies, in fact, and how we demonstrate independence through accountable officers whose budgets are set and obviously provided for in the government plan, but who retain an element of independence through their accountable officers in administering and apportioning the funds that they receive from government. So I hope that does exist, and as the Deputy pointed out, there are many other examples in and around government of similar structures. Deputy Rob Ward mentioned his concern about building confidence and any potential concerns that people may have about a lack of independence. I think I would simply ask the Deputy in this case to reflect upon the work of the whole office of the Children's Commissioner through this time. Every member of the office, I think, has demonstrated quite clearly their ability to champion children's rights, to work collaboratively, yes, but also without fear or favour, and to raise concerns when they have been necessary. And I think the President of the Scrutiny Liaison Committee and myself, when we met first to discuss this matter, were able to reflect on that. And I think this proposition shows that some time has now passed, and we have got to a good place where we feel it is appropriate to attempt to ask the Assembly for this further commitment and a minor amendment. Sir, I thank the Chair of the Scrutiny Committee, the Children's Scrutiny Committee, for their consideration and their very full and helpful comments paper. The Deputy is quite right to remind me to refer to the 2 points that they raised in their conclusions, and forgive me for not doing so earlier. We are currently always keen to look at pan-island solutions where we can support each other with our sister isle in delivering such bodies, and that's absolutely correct, and I'm grateful to the panel for the suggestion, and we shall seek the first opportunity to do so. In relation to the residency term, we are obviously somewhat in the bounds here of the Control of Housing and Work Law and the 10 years residency requirement, and so the panel are correct in identifying that that perhaps might be a barrier to a potential future commissioner, but equally it may be something that is welcomed by that person as they would see their role as coming in to do a specific role for a specific and known amount of time and then to exit stage left or right, as of course has the previous Children's Commissioner. And therefore I'm afraid that I cannot at this point see a workaround that would assist in that, other than of course them seeking other employment that would extend their time in the island under the confines of our current law. So I hope that answers the questions of members, and I hope that members will join with myself and the President of the Scrutiny Liaison Committee in adopting these two amendments to this piece of legislation. Thank you.
Very well, is the appel called for?
Yes, please, sir.
I invite members to return to their seats. The appel is called for. The vote is on the principles of the regulations. I ask the greffier to open the voting and members to vote. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted. 41 votes pour, 2 votes contre, 1 abstention.
Those voting contre, Deputies Tadier and Ward. And Deputy Scott abstained.
And Deputy Catherine Curtis, do I take it your panel doesn't wish to call this matter in? Very well. How do you wish to propose the regulations in second reading, Chief Minister?
I propose the regulations on block, sir. Shall I continue with my speech?
You can either answer questions on them or you can introduce them before proposing them on block, whichever you prefer, Chief Minister.
I'll propose them on block, sir. Thank you.
Are they seconded en bloc? Very well. Does any member wish to speak on the regulations or any of them? Deputy Tadier.
Thank you, sir. And if it is possible, first of all, to ask for these to be taken separately. I'm not sure if it is, sir, because there's a paragraph 1 and 2, but there are sub-paragraphs in terms of the alphabetization. Although I didn't speak in the principles, I think it's appropriate to speak in the articles to explain why I voted against and the misgivings I've got about the changes here. So the changes, first of all, don't relate to the length of term for the Commissioner. I think that's probably going in the right direction. I think 8 years is very long. Arguably 6 is still quite long, but these are not political terms of office we're talking about. My concern is that the changes that we're making, the substantial changes to broaden the scope of who can apply for the ultimate position of Commissioner when that becomes available, identifies a problem, but it doesn't find the correct solution. The problem is, or rather the starting point is quite rightly and should always remain, that whoever the Commissioner for Children is independent in fact and in appearance. The very fact that somebody in the Commissioner's office is effectively employed by the state's employment body is highly problematic. And I think that's the problem that needs to be resolved first before we were seeking to amend this today. Because irrespective of what one might say about safeguards, present or future, that doesn't sit right with an independent office. You can't have an independent office which is appointed by the state's employment board. What is the state's employment board, certainly in its current format? It's 3 members of the executive and 2 members of the non-executive. So effectively, in that sense, the state's employment board is a majoritarian ministerial entity. It might be called the state's employment board, but it could be interpreted as the government employment board. Now, I know that Deputy Mezek stood up earlier and said that there is a current safeguard in the sense that in order for this particular appointment to happen, it needs to be agreed by the Chief Minister of the day and the head of the Scrutiny Liaison Committee of the day. But of course, we don't know who those 2 people will be at any one time. And it's entirely possible that in a future iteration, you will have a member of the Scrutiny Liaison Committee who is a party member of government, a member of the governing party, or a member in coalition with the minister, with the ruling party, but not necessarily not in government, him or herself. And so you effectively have a system where the Commissioner is employed by the State's Employment Board, as are the current those members working in the office, and you could have a situation where you have somebody who's not independent and actually is in a political appointment to that position. And I think we owe our children in future better than that. I don't buy into this suggestion that enough time has now passed, that these changes were put in as safeguards initially, but there's enough water under the bridge since the Committee of Inquiry reported back. It's only in 2018, more or less, that it reported back, and the previous Assembly debated those changes, and we all stood up and said never again. And I think we're frankly being too complacent here. I think we should, I'm not going to propose it, but we should be doing this in a completely different way. This strikes me as being, unfortunately, I don't like to say a Jersey fudge. We've identified a problem, but not the real solution to it. And that's why I didn't vote for it in the principles. I can't support the relevant article, and I won't be voting for it in the third reading either.
Right. Before I proceed, Deputy, you made a reference to being able to vote separately. I'm afraid there are only 2 regulations. We can't subdivide the regulations. You must either vote for the regulation or not, as the case may be. Deputy Scott.
Thank you, sir. I just am voicing my continuing discomfort because the Chief Minister didn't answer my question about who is actually responsible for the budget and for the grants to the Children's Minister. Is it the could it be that the Minister for Education, who's responsible for children, herself? I just need to understand this a bit more, because like Deputy Tadier, I do have problems in terms of this potential conflict situation where you have employees of what are supposedly independent organisations that nevertheless are being employed by the State's Employment Board. I understand that there's an administrative convenience here, but it does seem to me that in terms of ministerial, the potential for some sort of interference or overdue influence in these areas needs to be addressed in terms of the way these things are set up. Thank you.
Does any other member wish to speak on any of the regulations, or the regulations generally? Other member wishes to speak? And I close the debate and call upon the Chief Minister to respond.
Thank you, sir, and I thank the contributors. It's important in this Assembly that we can all share our views without fear or favour, and to express a contrary opinion. And of course, that's what has happened, and I respect those differing views. In answer to the question from Deputy Scott, apologies for not addressing that specific point previously. I believe the Children's Commissioner budget would come under the Chief Minister's, and I can assure her that any the monitoring of that budget would be seen as an arm's length operation, and the Children's Commissioner and their office being accountable for their own management thereof. So with that, I ask for the appel, as I assume that some members may wish to register their discontent with this item, but I hope that the majority of members will remain as they were on the principles, sir.
Well, the vote is on Regulations 1 and 2, the entirety of the regulations. I'll ask the greffier to open the voting. Members have had the opportunity to cast their votes, and I ask the greffier to close the voting. And I can announce that the regulations have been adopted in second reading, 42 votes pour, 2 votes contre, no abstentions. Very well. Do you wish to deal with the matter in third reading, Chief Minister?
Sir, thank you. I do. Before I move the draft regulations in third reading, I would like to thank the President of the Scrutiny Liaison Committee for his input and cooperation in progressing these regulations. I would also, sir, like to pay tribute to the former Children's Commissioner who set... The former Children's Commissioner set a very high standard for the role and embedded children's rights successfully across the island, and particularly in many schools. She raised many issues in a fearless fashion, I think, and it was really quite a breath of fresh air to observe and to witness. And I'm sure that the next role holder will endeavour to continue as she did. This now allows the appointment process to progress, and I look forward to returning to the Assembly with the Deputy to propose the next Children's Commissioner once the appointments process has been completed. Thank you.
Are these seconded for third reading? Does any member wish to speak in third reading? No member wishes to speak in third reading? Then I close the debate. All those in favour of adopting in third reading? The appel is called for. I invite members to return to their seats. The vote is on third reading, and I ask the greffier to open the voting. If members have had the opportunity of casting their votes, and I ask the greffier to close the voting. and I can announce that the regulations are adopted in third reading, 42 votes pour, 2 votes contre, no abstentions. Very well. We now come on to the next item of public business, which is the draft probate amendment at Jersey law lodged by the Chief Minister. The main respondent is the Chair of the Corporate Services Scrutiny Panel, and I ask the Greffier to read the citation.
Draft Probate Amendment Jersey Law 2000 and Law to amend the Probate Jersey Law 1998. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Chief Minister.
Thank you, sir. The draft amendment law before the Assembly today would, if adopted, provide new arrangements relating to the management of movable estate in Jersey in certain limited circumstances. The proposed amendments update the existing small estate exemption in the Probate Jersey Law 1998, bringing it more in line with the arrangements already in place in England, Scotland, Guernsey and the Isle of Man. The amendments would allow people who, through banks and care providers, for example, are holding the movable estate of deceased people and to release it to others, for example, family members in certain limited circumstances. Movable estate is personal property that can be moved, such as cash, jewellery and furniture, as distinct from property that cannot be moved, such as a house. The movable estate can be a single item or multiple items. For ease, I will use the term personal property as opposed to movable estate. As matters currently stand under the law, a grant of probate or grant of letters of administration are required in respect of all deceased persons' estates, regardless of the size or complexity, except for where the deceased person was domiciled outside of Jersey and the value of their personal property was no more than £10,000. A grant of probate is required when a person dies with a valid will in place. A grant of letters of administration are required when they die intestate. Both cost money, take time, and can be viewed as overly onerous in the case of low-value estates where there is little complexity or risk, hence the numbers of small estates that are never claimed. The law currently makes an offence for a person to administer the personal property of a deceased person before a grant is in place, which effectively means that a hospital nurse who gives a deceased patient's possessions to a grieving relative is potentially inadvertently committing an offence. Our care providers are in the difficult position of either holding on to the personal property of a deceased person, thus denying family and friends access to items of sentimental value, or acting in a supportive manner, which is potentially unlawful. This is not a desirable position. This amendment, therefore, proposes that the law is amended to provide for limited circumstances in which a person may give a deceased person's property to another without or before a grant of probate or administration. For the purposes of clarity, the proposed amendments to the law would not remove the general requirement for the person managing the estate of a deceased person to apply for and receive a grant of probate or administration in order to establish their right to recover or receive the deceased person's estate. The amendments will simply provide for exceptions by setting out specific circumstances in which the person holding the personal property, the holder, may give it to another person where there is no grant in place. A grant is still required other than in accordance with 5 limited circumstances. The first exception relates to small estates. A person holding a deceased person's personal property may give it to another person without that person having a grant if the deceased person did not live in Jersey and the gross value of their personal property in Jersey as held by the holder does not exceed £30,000. Or the deceased person lived in Jersey and the gross value of their personal property held by the holder does not exceed £30,000 and the gross value of the deceased person's worldwide personal property does not exceed the same value, £30,000. This would, for example, allow a bank to release a deceased person's monies to a family member. One practical example, which is sometimes the case in Jersey, would be for the family to access a co-op dividend account, for example. The new exception is similar to the the new exception is similar to the exception that currently exists in law where the deceased person did not live in Jersey, except that it increases the threshold from £10,000 to £30,000. The new exception also applies to deceased people who are domiciled in Jersey as opposed to just in another country, and it sets the threshold at £30,000, a threshold that is currently £50,000 in England, £36,000 in Scotland, and unlimited in the Isle of Man and Guernsey. £30,000 represents a risk-averse approach as we move to new arrangements. The Minister may, however, increase or decrease the amount by order in the future as appropriate. The amendment law would introduce safeguards to protect against an applicant acquiring property they are not entitled to, and to protect a holder if they are unknowingly give property to someone who is not entitled. These safeguards include the applicant acknowledging in writing that the holder is not liable if another person or family member claims the property was rightly theirs, and the applicant declaring in writing that they're entitled to the property under the terms of the deceased person's will or laws relating to intestate succession. Furthermore, the law proposes that the exceptions cannot be relied on if there is a caveat to force preventing anyone from disturbing the deceased person's property. Details of all caveats are listed on the government website or on the physical notice posted outside the Royal Court building, so may be readily checked by any person. An amendment is also proposed to protect the holder from any potential action brought by the deceased person's estate, providing the holder acts in good faith. It is important to note that the holder may choose to use the exceptions introduced in the law, but they are not compelled to. If they have any concerns about releasing the personal property of a deceased person, for example, if they know there is a dispute within a family, they may refuse to release the applicant provides them a copy of a grant. The second exception has the same effect as the small estate exception, but is brought forward to provide ease and certainty to care providers who often find themselves holding the possessions of deceased people. This will include care home managers and delegates of the chief nurse to be set out in an order. Under this exception, the holder may release the property to a family member, friend, or another relevant person on receipt of a completed application form, forms which will be readily available online. As with the small estates exception, a £30,000 limit applies, so the applicant will need to declare the value of the possessions, and the holder will need to make a judgment as to whether the declared value appears correct. Furthermore, the applicant is required to declare that the gross value of the worldwide estate of the deceased personal property does not exceed £30,000. In most cases, common sense will help the holder to determine if the items are worth more than £30,000, but they can look at similar items online or seek a valuation if they deem it necessary. The third exception provides for funeral directors to authorise, without a grant of probate or administration, that a deceased person may be buried or cremated with personal items up to £1,000 in value, such as a wedding ring. Furthermore, a funeral director may authorise items up to the value of £10,000 to be buried or cremated with the deceased on receipt of an application form completed by the applicant, which, as before, will be readily available online. In both cases, the property must have been worn by the deceased or be with them at the time of their death. A fourth exception allows the Viscount, when appointed as delegate for the deceased person under the Capacity and Self-Determination Law, to release that property without a grant, where the Viscount is satisfied that the gross value of the worldwide estate is not more than £30,000, and where it is for the purpose of legitimate expenses such as a funeral bill, care home fees, or reimbursement of pension or benefits overpayments. Under common law, the Receiver General may receive, on behalf of the Crown, bona vacantia or ownerless property. Under the fifth exemption, that would be introduced by these amendments, the holder may release and the Receiver General may receive without the production of a grant if the holder, despite reasonable effort, cannot identify a person to whom the movable estate should be released. For the purposes of clarity, customary law is not affected by these amendments. Legitime, the protection from disinheritance provided in law remains as is. Any person who believes that the terms of another person's will deprives them of estate to which they're entitled may still bring action under law. The draft provisions before the Assembly, sir, also amend the offences which are currently set out in law in order to recognise the new exceptions and to introduce a new offence in the event of a person knowingly providing false information when requesting the release of personal property. The existing offence of intermeddling remains unchanged, except that the drafting language is updated as per Article 13 of the Interpretation Law, which provides that where more than one penalty is specified, the word "and" means from the penalties may be imposed alternatively or cumulatively. The draft law also proposes introducing an enhanced regulation-making power, allowing this Assembly to further amend the law by regulations in the event, if it deems necessary, to do so without recourse to the Privy Council. So these amendments were originally developed with support and guidance from the Legislation Advisory Panel, and I'd like to thank them for their work. They have been the subject of a public consultation process which ran from October to December 2021, with comments received from the Jersey Bankers Association and the Law Society, both of whom welcomed the proposals in principle. Both raised queries, and we worked to address through refinement of the draft provisions, most notably by ensuring that the provisions adequately protect the holder against any action taken by a third person who believes they're entitled to the personal property, and by ensuring that the holder need only be satisfied that the value of the property they hold is no more than the £30,000 threshold. i.e., we are not asking the holder to account for things that they cannot know. We also directly contacted all care homes and funeral directors to ask them for initial comments, and more recently they were sent guidance on how to proceed, and further guidance meetings have been scheduled with them in the event that the Assembly chooses to adopt this proposition. So I believe that the amendments before the Assembly today represent a proportionate and a sensible way for people to proceed when dealing with low-value estates. They avoid the expense and time associated with obtaining a grant of probate or letters of administration, where the risk of wrongdoing is low. Plus, they provide more assurance to our care providers and funeral directors that they can act with compassion without potentially committing a criminal offence. So I recommend the amendment law to the Assembly, and I move the principles of the proposition.
Are the principles seconded? Does any member wish to speak on the principles? Deputy Mezza.
Thank you, sir. The Corporate Services Scrutiny Panel hasn't conducted a full review on this law, and the reason for that being that one was unnecessary because the previous Corporate Services Panel did just that and produced comments when a previous iteration of this law was brought at the end of the last term of office, and that led to that iteration being withdrawn so that the comments of that iteration of the Corporate Services Scrutiny Panel could be taken on board by the new Chief Minister, who coincidentally happens to be the chair of that panel that made those recommendations. And so that has been taken into account. And since then, my panel did have a comprehensive briefing on this new version with the changes in it that have been made, and we are satisfied that that has been drafted in an appropriate way and that those comments were taken into account, and we are satisfied to say that we can support this iteration of this as a step forward that will probably make things easier for some people when they're unfortunately going through difficult times. So we're happy to support it on that basis.
Thank you very much, Deputy Constable St Mary.
Thank you, sir. As the Chief Minister said, the Legislation Advisory Panel of the previous Assembly did originally bring this legislation forward in much the same form. Whilst it was delayed, the panel of the day were very much in favour of it, and certainly I have no problem in approving it. I rise simply, sir, to perhaps make a particular distinction on the exception for small estates. As the Chief Minister said, there is a distinction between the situation where the deceased died domiciled in Jersey and where the deceased died domiciled outside Jersey. Where the deceased died domiciled in Jersey, the small estate exemption applies to a limit of £30,000 total. If the deceased died domiciled outside Jersey, the deceased could have multitude accounts, I think. Deceased could have accounts in more than one place, where in each the limit was £30,000. And so in that case, someone dying outside Jersey, someone domiciled outside Jersey could die leaving assets in the island of more than 30,000. Because of my previous involvement, the department did run this past me, and I queried why the distinction, and the answer was to the effect that it would be difficult for any one institution in Jersey to take a view as to whether the deceased had other accounts when they were not domiciled here, and that seemed reasonable to me. And I simply flag the point so that members are aware of it. And as I say, sir, I'm very happy to approve the proposition as drawn. Thank you.
Deputy Southern.
Thank you, sir. Only one point to make, or question to ask, but it's a very general one, because I heard the words by order. The Minister may change these terms by order. And as soon as I hear by order, I think, what's the justification by order? It's very convenient for the Minister to be able to do that, and often that's justification enough. But I would seek some argument, some justification as to why it should be by order and not by regulation. Remember, regulations come to this House, we get a say. If the Minister of the time, in some future date, wants to make this 30,000, I don't know, 3 million, then that might cause an issue. But bring it to the States and we can decide what the right level is, rather than the Minister off their own bats saying it's by order and by regulation. Get your nose out of it. So some sort of explanation as to why by order instead of by regulation, please.
So any other member wish to speak on the principles? No other member wishes to speak on the principles? I call on the Chief Minister to respond.
Thank you, sir, and I'm grateful to those who have spoken. I think if anybody ever doubts the value of scrutiny and the process, then this is a good example of scrutiny in action, having been very familiar with this proposition from the other side. And of course, I'm grateful to the current chair for acknowledging the work of a former panel and the changes that have been brought in this proposition today. We're also grateful to the Legislative Advisory Panel and the work of the Constable of St Mary. To answer Deputy Southern's question with regards the justification for simply being able to make changes by order, I think it would be a very brave minister who made a radical change to this proposition by order, and I'm sure that Legal Beagles and others would identify such a change and take issue, and that would be pursued through the Assembly in forms of questioning, and they would be able to therefore seek a change. But also, I think if we reflect in the rather lengthy speech I gave in opening the principles, we can see that if we look at Guernsey and the Isle of Man, where there is no limit to the amounts, then that shows that there are differing views and approaches taken in various places, and so I do not think that it would be an outrageous suggestion. So I commend the principles to the Assembly and ask for the appel.
That is called for. I invite members to return to their seats. Vote is on the principles. I'll ask the referee to open the voting and members to vote. Members have had the opportunity of casting their votes. I ask the referee to close the voting. The principles have been adopted. 44 votes pour, 1 vote contre, no abstentions.
Deputy Southern voted contre.
Do you wish to... sorry, does the Deputy Mezek, does your panel wish to call the matter in?
No, sir.
How do you wish to propose the articles in second reading, Minister?
En bloc, please, sir.
Are they seconded en bloc? Are they not seconded for a second reading? Does any member wish to speak on any of the articles? No member wishes to speak. Those in favour of adopting the articles in second reading kindly show. Those against? The articles are adopted in second reading. Do you move in third reading?
Thank you, sir. I would simply like to express my appreciation to the policy officers, the law officers, and scrutiny officers and panel members who have contributed to this work, and to those who have contributed also to the public consultation, along with the members of the current and the previous legislation advisory panel. They have all contributed to the progress of this proposition, and their support and assistance in informing and developing these proposals has been most helpful. So I move the third reading.
Is it the law seconded for third reading? Does any member wish to speak in third reading? No member wishes to speak in third reading. I close the debate. All those in favour of adopting the law in third reading kindly show. Those against? The law is adopted in third reading. The next item of public business is the draft Control of Housing and Work, Residential and Employment Status Amendment Number 2 Jersey Regulations lodged by the Chief Minister, and the main respondent is the Chair of the Corporate Services Scrutiny Panel, and I ask the greffier to read the citation.
Draft Control of Housing and Work, Residential and Employment Status, Amendment Number 2, Jersey Regulations 2000. The states make these regulations under Articles 2 and 44 of the Control of Housing and Work Jersey Law 2012.
Chief Minister.
Sir, can I declare an interest here?
Yes, certainly.
I have a personal interest that the matters within this actually would be a qualifying feature for myself and my partner. So I will declare that an interest.
Very well.
And so the rapporteur for this proposition is the Assistant Chief Minister, Deputy Stevenson.
Thank you very much, Chief Minister. Deputy Stevenson.
Thank you, sir, and thank you to the Chief Minister. I'm very pleased to be bringing this, proposing this small but significant change to our current controls on the employment of migrants. The Council of Ministers is committed to addressing the labour shortages that many employers are currently facing. And these regulations will remove a barrier which stops an unmarried partner of a migrant worker or local resident from accessing the local employment market. It's a simple fact that the proportion of adults who are married has declined over the last several decades, and this proposed change therefore provides a more effective use of the skills and experience of unmarried partners who move to the island or are in a relationship with a partner already here with entitled, licensed or entitled for work only status. A typical example is that of a teacher who comes to Jersey with a licensed permission. Her unmarried partner is an experienced graphic artist. At present, the partner is limited to registered jobs. With the new regulations in place, the graphic artist would be able to use their skills to support any local business. Another example is that of an entitled Jersey resident who's left the island to take up employment elsewhere. At present, should that entitled person return to the island with their unmarried partner, the unmarried partner is limited to registered jobs. With the new regulations, they'd also be able to use their skills to support any local business. The 2-year period for evidence of the relationship is aligned with the existing requirement under immigration rules. Any partner coming from outside the common travel area will already need to satisfy this condition to enter Jersey. And as well as those moving to the island, this proposed change aims to deliver an improved use of those persons already on the island as partners of current workers, which will assist the supply of workers in areas across the economy and help to reduce labour shortages. Looking very briefly at the legal framework, the Control of Housing and Work Jersey Law 2012 provides controls on who can live and work in Jersey. The Control of Housing and Work Residential and Employment Status Jersey Regulations 2013 sets out the conditions for residential and employment status under that law. Spouses and civil partners of those with entitled status, licensed status, or entitled for work only status under the Control of Housing and Work Law already receive entitled for work only status under the regulations. Entitled for work only status provides open access to the local labour market. It allows an individual to take up any local job and does not require an employer to have any permission to employ that person. Unmarried partners currently do not acquire any Control of Housing and Work status from their partner, and this means that these individuals are restricted to registered jobs on arrival in Jersey and for the first 5 years of their residence. In short, these proposed amendments to the 2013 regulations will give unmarried partners the same employment rights as partners who are married or in a civil partnership. They will allow an unmarried partner who's been in a continuous relationship akin to a marriage or civil partnership of 2 years or more with a person who holds an entitled, licensed, or entitled for work only status to benefit from entitled for work only status. The intention is that this change would take place 7 days after approval by the States Assembly. Sir, I'd be glad to answer any questions that members may have, and I propose the principles.
Are the principles seconded? Does any member wish to speak on the principles? Deputy Mesek.
Thank you, sir. Members will see that the Corporate Services Scrutiny Panel have lodged comments to this, and we received a briefing from the Assistant Minister and an officer before putting these comments together. It struck us that the change that's proposed by this is absolutely right. It will eliminate an inequality that exists in the current system and align the rules for unmarried couples now to what already exists in other parts of the immigration system anyway. So it struck us as a simple way of eliminating that inequality without having to introduce new systems or new bureaucracies to try to deliver on that. So on that basis, we're absolutely content to support this, and it will be interesting to see whether the impact it has on our labour market is positive, as we of course hope that it will be. Speaking now, I guess more on a personal note than rather with scrutiny, it does still have to be said that our migration system, having a Control of Housing and Work law and the system that we have now and qualifying periods for those rights, is fraught with all sorts of difficulties. It creates difficult situations for families which come in all shapes and sizes with all sorts of different arrangements, and between them inside and outside of marriage, or different arrangements with children, etc. And there are some great problems with that, and in particular how things can impact on children when there's a relationship breakdown, and the impact that that can have on the parent who may become the primary carer for those children, who may suddenly find that they're having to move out of a home that they had on the basis of their previous relationship, or and worries that there may be about what impacts that might have on their employment status too. So I raise that simply to say on record, whilst this is most certainly a positive step, when wider work is done on our population policy and how we accord people working and housing rights in Jersey, that the consideration we have to those people's human rights must be a greater consideration than it appeared to be when the Control of Housing and Work law was originally put together.
Deputy Scott.
Thank you, sir. I just would like to add my voice to applaud the Chief Minister, Assistant Chief Minister, for bringing in these regulations. We do have a severe labour shortage in Jersey, and it's good to see this happen. I just remain totally bemused that it hasn't happened earlier, seeing that in 2013 that this rule was changed for some key workers, but not for all workers. And I just hope that there may be some sort of learning here, because to me it illustrates two patterns I've seen in government, particularly in terms of valuing existing skills. And one is looking at gift horses in the mouth. And the other is closing the stable door after it has bolted. There have been people in the island who haven't been able to work, who could have been valuable resources. And I'm just sorry this didn't come earlier. Thank you.
Very much, Deputy. Deputy Doublé.
Thank you, sir, and I too thank the Chief Minister for bringing this forward, and I recall the conversations very early on in the Education Minister's term of office, and I'm so pleased that there's been swift action on this. I think it will have a really positive impact. And I wanted to echo what Deputy Mezek raised, and he put that in the context of population policy. And as I was reading this proposition, and I'm in agreement with it, and very much in agreement with it, to the extent that one of the concepts within this proposition of the enduring relationship, and there's a definition within the wording of the proposition of the enduring relationship being a cohabiting partner. I think it's 2 years, isn't it, of a duration of 2 years without any breakdown. And I do wonder why we don't have that definition extended to other areas of law, because one of the, I think, kind of unheard issues of our population is that misconception that we have something called common law marriage, which in other jurisdictions there is, that concept is established in law, but we don't have it in Jersey. And people often only realise this, again, Deputy Mezek mentioned this, people often only realise this when a relationship breaks down, and especially when the couple have children, that they can find that one or other of the couple doesn't have the rights that they thought they did, and isn't entitled to things that they thought they might have been entitled to. And there can be real hardship caused as a result of that misconception. So I'm not sure which minister would be responsible for looking at this. I think it's probably the Chief Minister, because it is quite a broad, wide-ranging thing. But I just think, seeing as we have made this step, and seeing as it is something that I recall Advocate Rose Colley raising this and campaigning on this, and other people have raised it in the media in recent years, that I do think it's something that we should look at. And this proposition shows that a definition is possible to make a definition and to utilise it within a law, so that we should perhaps look at this in a wider sense to make sure that people aren't deprived of rights which they thought they already had.
Much. Does any other member wish to speak on the principles? Deputy Coates.
Thank you, sir. I won't take long to speak on this one. I am in support of the proposition, especially from an economic development standpoint. I think when we look at the productivity we require from our workforce, we best make use of the people who are here, and we must welcome the people who are here. A couple of points I would note. In the proposition, it does mention that the burden of proof is on the applicant for this. And I have to agree, and I think we have to always be clear. Sometimes there's an expectation that government should never be able to invade or to understand. It's not about invasion, but I think for a system like this to work, we have to have a fair expectation between applicant and department in administering this, that sometimes personal details are shared. Photos, there's a mention about you can do this through obviously showing residence, financial ties, and through, basically a bona fide relationship, the things that make up a relationship. So there will be an expectation on sharing that. So I think we need to be clear that that is the case. Likewise, though, the second part I was going to say is then there has to be an expectation that the officers administering this system and this set of tests do so with compassion and empathy. It is a continual gripe of many of our constituents that the way they feel treated by customer local services and by many officers sometimes is brilliant, but sometimes, often for those dealing with immigration and workplace and workforce requirements, is less than ideal in the way they feel welcomed. We need, to take the benefit of the doubt in the way our officers take a language to people, while still having a rigorous and robust process. And finally, the last one I was going to add was, I think this is a good chance for us to remember that the Assembly has to be able to revisit the decisions it makes. This may not be the right component for controls on housing and work, or in this case work, for time eternal. We may have to revisit this, and we can do so as long as we are not retrospective on individuals impacting their lives, and we also provide enough runway to make sure the change accommodates individuals and the way they have planned. So those are the comments I'd make around this, obviously being in support of the principles.
Very much indeed. Deputy Andrews.
Thank you, sir. I'm very pleased, actually, to see this be brought forward. As members are aware, at the moment we are dealing with a tight labour market, and it is making it very difficult for ministers at the moment who, for instance, are trying to move the island forward, and also for non-executive members as well, because we are seeing the island currently go through a period of double-digit inflation. We have also seen the Bank of England continually increase the base rate, and we also must bear in mind as well that Jersey is a very costly jurisdiction. So in order to actually try and attract the right people here and also the right skill sets, it's proving to be very difficult as it is. But I think this actually provides us with more flexibility. And I'm also aware, in response to one question that I asked about the number of vacancies in the public sector, I think there's a total of 671 vacancies. So we need to try and aim to get those jobs filled, and especially when we are looking at our healthcare service as well. I think we desperately need people, and I think this is going to provide us with the right opportunity and resources to get the right people into our island. I think there potentially could be maybe some sections of our society that, maybe don't like to see, people coming into the island. They maybe don't like talk of net inward migration, but it's absolutely crucial that we do see people coming to the island. I think it's also important to realise that Jersey is better being a cosmopolitan island compared to one that is based on communitarianism. We have to modernise, and I think it's going to allow us to actually be a better island by having different nationalities in our labour force. I think that's really key. And we just need to look at other jurisdictions who've really excelled by embracing a cosmopolitan society. And I think that's something that I certainly stand for as a politician, and I hope my colleagues do as well. And I think this is a good opportunity for people who choose Jersey as their new home. It might be that, say, one individual is looking to return with their partner. And I think we should really give them the opportunity to take up job opportunities that, for instance, certain individuals are trained in, instead of being constrained to registered work only. So I am in support of this, and I must thank the Chief Minister and the Assistant Chief Minister for bringing forward the regulations before the Assembly. Thank you.
Thank you, sir, and I'll be brief. For me, it's the first and very important steps of outcome that group, Population and Skills Ministerial Group, thank you for the Chief Minister and Assistant Chief Minister that I remember, that we actually listened what public would like us to do and act quickly, and the response what people was expecting, that we'll start to make changes and adopting our legislation as quick as possible. I know it could be quicker, but it's still legislation. I remember my first meeting with all head teachers when I was elected, and it was several points raised, and one of the points very clear, why eligible unmarried partners are discriminated compared to the married and civil partners. And it was a very clear message, and it took some time, and I'm pleased that we're today here and doing our first step, and we're responding to what public would expect us to do, at the same time addressing our recruitment challenges, because this would help in small way, in step way. It will not completely sort out our recruitment challenges, but it's like a jigsaw puzzle that we need to continue to move forward. So thank you for all officers and the ministers that worked on this together.
Any other member wish to speak on the principles? Other member wishes to speak on the principles? And I close the debate and call upon the Deputy Stevenson to respond.
Thank you, sir. And I'm really very grateful to all the members who've contributed to this debate. I think I'm really very pleased with the general mood of where these comments have gone, not just because they may be in support of it, but around the welcome to Jersey and actually the opportunities for migrants and the language that people are using about the part that people have to play in our community. I think that's really very encouraging, and we should all recognise that as well. Turning just to some of the questions and the points made, I'm also grateful to Deputy Mezek and the Corporate Services Scrutiny Panel for their helpful comments ahead of the debate today, and the conversations, how it aligns with immigration rules. I will take on board the comments that he made in the second part of his speech. Of course, we recognise that families have very individual circumstances along the way, and it's not always easy or simple to reflect that in legislation. I think flexibility and being able to flex for those scenarios and really recognise and value people as individuals and their circumstances is really very important. So I note those concerns and reassure you that we will take those back as we continue this work as well. Deputy Scott, I'm obviously grateful for her support on this matter, and I would just seek to reassure her that we are working to take action on the important issues that she raises. And I think, as Deputy Gardner has just said towards the end there, this is one small step, but I hope is part of a much broader piece of work by lots of different ministers and working groups, all feeding into this aim of really taking action on the issues that Deputy Scott raises there. Deputy Doublé raises a very interesting point around common law marriage there as well, and I think perhaps that is something we can consider, and maybe we take a moment to review where there are mentions within the laws and see if references could be made to enduring relationships rather than common law marriage, or where that doesn't exist at all perhaps, and that is something that we can take away from this. So I appreciate her contribution there as well. Deputy Alex Curtis, again, grateful for the support, and I think, again, some real compassion and empathy points made there, which then were reflected in the speeches of lots of other members. And again, I think this just talks to the general point I made at the beginning, that it's really very encouraging to hear those kind of comments in this assembly and feel a sense of agreement from everybody on those. I absolutely agree that the welcome to Jersey and how we treat migrants and as part of our community and as islanders, my view is if somebody lives here, they are an islander. And so I absolutely agree on that point as well. Deputy Andrews talked about the tight labour market, and I think, we really, as again Deputy Gardner said, this piece of work came out of really hearing that kind of feedback, and where there may be opportunities to make some quick, within reason, when it comes to legislation and regulations, changes on that. So again, it's important to note that is what we are working towards. That is the common aim here. I also believe that it will benefit from a recruitment and retention point of view, hopefully. So as well as attracting people to the island, also attracting people back to the island, and then hopefully retaining them once they are there as well. I think I've touched on Deputy Gardner's points, but she perhaps read the small notes that I'd made about my concluding speech, but it was just to recognise that this small but significant step follows discussions by that Population and Skills Ministerial Group, which was set up by the Chief Minister during our first 100 days to coordinate policy in this area. And in my view, this proposal is an example of how that forum is working proactively together to identify positive opportunities for action, which help to deliver the strategic priorities adopted by this Assembly, specifically those relating to the economy, the ageing population and the community. And with that, sir, I maintain the principles and ask for the appel. Thank you.
It is called for. I ask members to return to their seats. The vote is on the principles. I ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted. 46 votes pour, no votes contre, no abstentions. Can I assume that the scrutiny panel does not wish to call this one in? How do you wish to deal with the matters in second reading?
En bloc, please, sir.
Are they seconded en bloc? Does any member wish to speak on any of the regulations? If no member wishes to speak on any of the regulations, then I close the debate. All those in favour of adopting the regulations kindly show. Those against? The regulations are adopted in second reading. Do you move in third reading?
Yes, sir. Maintain the regulations in the third reading, please.
And, are they seconded for third reading? Does any member wish to speak in third reading? Those in favour of adopting the regulations in third reading, kindly show. Those against? The regulations are adopted in third reading. Very well. The final item is amendment to standing orders remote participation in states meetings lodged by the Privileges and Procedures Committee. The main respondent is the chair of the Corporate Services Scrutiny Panel. I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion to rescind their act dated 14th of September 2021, in which they adopted the proposition entitled States Meetings, Continuation of Remote Participation, P87 of 2021, and to make the following amendments to the standing orders of the states of Jersey with immediate effect. 1. Standing Order 55A, members present and able to vote by means of electronic communication in exceptional circumstances. For paragraphs 1 and 2, substitute the following paragraphs. 1. This standing order applies only in the following instances. A. During the period of a state of emergency, as defined by the Emergency Powers and Planning Jersey Law 1990, when it is not possible to convene or maintain a quorate meeting of the states in person. B. At any other time outside of a period of a state of emergency, if the bailiff considers that it might not be possible to convene or maintain a quorate meeting of the states in person in view of substantial risk to the health of members of the states or any other person. And C. To any member who is absent at the start of a meeting day or continuation day for a reason related either to the member's health or to the health of a family member or household member of that member, and who has requested to participate remotely in the meeting. 2. Where this standing order applies, the greffier must make arrangements to enable the members affected to participate in the meeting by means of electronic communication, provided that, in any instance arising from paragraph 1C, to do so would not be detrimental to the health of the member concerned. The arrangements may include the meeting being conducted entirely by means of electronic communication. 2A. The bailiff, following consultation with the Privileges and Procedures Committee, must issue guidance on the interpretation of paragraph 1C. 2. Standing Order 55A, members present and able to vote by means of electronic communication in exceptional circumstances. After paragraph 2A, insert the following paragraphs. 2B, notwithstanding paragraph 1, where, due to unforeseen circumstances, an elected member is unable to be in Jersey on a day on which the States is meeting, the member may participate in the meeting that day by means of electronic communication from outside Jersey. 2C, the bailiff, following consultation with the Privileges and Procedures Committee, must issue guidance on the interpretation of unforeseen circumstances in paragraph 2B.
Connie.
Thank you, sir. PPC has lodged this amendment to Standing Order 55A in order to address two States Assembly decisions, namely P87-2021, lodged by former Deputy John Young, which enabled remote or hybrid sittings in any circumstances. The second addresses the first part of P63-2022, lodged by Deputy Gardner, which related to remote participation when outside Jersey in the event of unforeseen circumstances. Just to remind members that Standing Order 55A is the provision which enables remote or hybrid meetings of the Assembly. It was introduced in response to the COVID-19 pandemic and the impact it had on the Assembly's ability to meet in person. If adopted, the amendment requires guidance to be issued by the bailiff in consultation with PPC. The bailiff has already drafted the guidance, which we have appended to the proposition. I hope this will be helpful to members in considering the amendment and assisting with the interpretation and application of these proposed changes. Therefore, sir, I will now briefly run through the amendment and the two changes it would make. The first part of the amendment would, if adopted, enable members to participate remotely in States Assembly meetings when they are unable to attend in person for health-related reasons, provided that it would not be detrimental to their own health. This amendment must also enable members to participate remotely when the reasons relating to health relate either to a family member or to a household member. This would mean that remote participation is always available, depending on a member's individual circumstances, rather than merely during set periods of emergency or public health crisis. I just want to make it clear at this point that the introduction of this facility is not intended to place undue pressure on members to participate when they are ill. The adoption of this amendment does not remove the ability for a member to be marked as malade, nor does it remove the ability for a member to be marked as absent due to parental responsibilities. Members will see that this has been reflected in the drafting of the amendment and is mentioned in the bailiff's guidance. I think it is also important to note that, if this part of the amendment is adopted, it will still remain possible for the bailiff to convene the Assembly remotely in times of emergency, or where the bailiff feels it would not be possible to convene or maintain a quorum meeting for public health reasons. I come on to the second part of the amendment, which would, if adopted, enable a member to participate in meetings remotely when they are unable to be present in Jersey, and therefore the Chamber, due to unforeseen circumstances. These circumstances are determined in the bailiff's guidance following consultation with PPC, and state that unforeseen circumstances include weather conditions which have impacted on travel arrangements and delay the member from returning to Jersey on the day they had planned. The bailiff has also included matters in relation to public health guidance or health-related reasons which prevent the member concerned from travelling back to the island when initially planned. The provision cannot be used by any member for remote participation on any day when they are outside the island on state's business, including days on which it had been planned for them to travel. This is stated clearly in the bailiff's guidance. Before going to the debate, I just want to reiterate the last part of the bailiff's guidance, which concerns both parts of the amendment. Members are required to judge for themselves whether to request remote participation in a state's meeting on the basis of the criteria set out in the guidance. The State's GREF will not police or ask for information about either the health reasons that may apply or the unforeseen circumstances that have arisen if a member is out of the island. Members must therefore be aware that if they are found to have requested and used remote participation inappropriately, this would be a breach of standing orders and the Code of Conduct for elected members. The PPC will reserve the right to monitor the application of the guidance, including the ability to ask for the reasons why remote participation has been requested, and to propose that such a request be refused in instances where the guidance has been misused. I hope this offers some reassurance to members that PPC will be monitoring closely the use of these provisions. We expect that the guidance may well need to change over time if it appears the process is not working. There are gaps within the process, or indeed if it is being misused. Sir, I make the proposition.
Is the proposition seconded? Does any member wish to speak on the proposition? Deputy Aye.
Thank you, sir. I am sure that all members are familiar with the State of Jersey Law, Schedule 2, Part 1, where the oaths to be taken by deputies are included. This states, as I'm sure members will recall, that you will uphold and maintain the laws, privileges, liberties and franchises of Jersey, opposing whomsoever may wish to infringe the same, and that you will attend the meetings of the state whenever you are called upon to do so. I believe that this is crystal clear, and that if we accept this proposition today, we will be accepting that the oath can be dispensed with. It is also mentioned in standing orders under Schedule 3, Code of Conduct for Elected Members. Here it states under Part 2, heading Public Duty, that elected members must give due priority to attendance at meetings of the states in accordance with the terms of their oath of office and should be present in the chamber when the states are meeting, unless they have very compelling reasons not to do so. Being on a beach in the Canary Islands is not a compelling reason for absenteeism. Once again, I believe that this is very clear guidance and that should not be amended in any way. Most members will recall the case of Senator Sivray, who lost his seat in the Assembly due to deliberately flouting Article 8, Roman 2 of the State of Jersey Law 2005. It asserts that a person who is an elected deputy ceases to hold office upon the expiry of a period of 6 months during which the person has not been resident in Jersey. It seems to me that this law would also be very difficult to implement if P21 is adopted today. Trying to determine whether a member was out of the island would become extremely difficult if they joined an occasional States Assembly online. We may also find that we create a new type of States member, a backwoodsman, or if I may use the term, a backwoods woman. This is quite common in the House of Lords. Since 2015, there have been 58 peers who have never attended the Palace of Westminster. It would be a sorry situation indeed if we created a similar scenario in our chamber. We must also consider how this will be perceived by the voting public and how this proposal will be received by the whole of our community. How are we supposed to encourage the electorate to engage in the political process if they perceive that doing so would result in their deputy never having to physically attend the States Chamber during their term of office? Is this the message we wish to send? I would like to ask the Chair of PPC if she would be willing to take Part 1 and Part 2 separately, and if so, I would advise all members to vote against Part 2 of this proposition. Thank you, sir.
Deputy Scott.
Thank you, sir. I just found the previous, the deputy speech somewhat perplexing. I feel that paragraph 2 actually is relevant to paragraph 1, but more than that, it was the description that perhaps by approving this amendment that we would end up with potential backwards men and backwards women. I'm really wondering who's backward here, because we're in the 21st century, and we actually are the beneficiaries of technology that do enable us to do things which our predecessors couldn't, and in circumstances where we might otherwise have been unable to do them. So I personally do not see a problem with regarding states members who happen to be online due to unforeseen circumstances as something that means that they are not present for a meeting. They are present and they are attending by electronic means that are now available in this century. So I am supportive of this amendment and welcome Deputy Ahir to the 21st century too.
Just to say, Standing Order 77 means that an elected member may request that any standing order is voted upon separately. So you have a right to ask for separate votes. Very well. Does any other member wish to speak? Deputy Rob Ward.
Thank you, sir. And I share concerns of Deputy Ahir. And I don't think this is about the mode of employ in which we engage in this assembly. It's about the nature of this assembly. We, in the last assembly, went through a very difficult time with COVID, and this assembly and the Greffier and their staff enabled an assembly to happen when in other areas it wasn't happening. And that was a remarkable feat. And when we functioned and we passed laws and legislation when that happened. But it was an extremely unpleasant experience to be sat at home constantly, and I don't think it was the right thing for us to do in normal times. And so what I would say is we haven't had a period of normal time to see the effect of that part of the history of this assembly and the online attendance before we make changes that allow that to be extended. And so there was a phrase used by Deputy ISO where he said due priority, and I absolutely agree. There has to be a due priority for us to stand in this assembly and debate. There has to be a due priority to bring propositions, a due priority to bring questions. Some members may find them inconvenient because it takes their time. This is your due priority, standing in this assembly now, being here and being part of our democratic process. And recently, sir, when we had guests from the British and Irish Parliament, we brought them to this assembly because we were very proud of this assembly to show them the way that we do that. And it was a really good visit. And there was a lot of very positive feedback about what was happening because of that, because it was unique. And we must not lose the unique nature of our democracy. And part of that is being here. Now, my concerns are, part one I could probably accept. However, so I will say, I didn't know whether to say this, but I think I will because I think it's important. It's very difficult when you talk about your health and whether you should attend. And I don't want to see people unduly pressured to attend if they're in ill health. I don't want to see people feel that they have to participate, and that word participate can be one of many things. It could be just sat and pressing a button to vote, or it can be actually speaking and considering. And if you are ill, you shouldn't. So, as you know, and I'm going to try not to catch your eye or the Greffier's eye when I say this, some time ago I had to undergo a bit of surgery, and I was insistent that I was going to attend this assembly online. And I was advised not to because it was it was a couple of weeks after. But no, for some reason, sir, I don't know where I get it from, but I was a stubbornness, whereas I will attend and I will do that online. And if I'm honest, sir, it was the wrong decision on my part. It was entirely the wrong decision because I was not putting my health first. And it was a silly thing to do. And what we're doing is we're enabling decisions like that because we are all committed to what we do. I'm very privileged to be elected to this assembly. So we need some checks and balances in place, I'm afraid. The other side of this coin is that there is no issue for me if people have families and they have to look after their children. The most important thing is family. And I absolutely say that. And so if we can enable people to be off with families, that's absolutely fine. But when you are off with your family, sir, you have to look after your family. And there's another issue that comes from any profession, anything that you're massively committed to, that actually you make do at that time when they need you most. And I don't want to pressure anybody into that position. And I find it very difficult, therefore, to vote for something that may even try to do that, which is why I do feel very opposed to this. And then so there's the nature of unforeseen circumstances, and so there will be asked to be made judgments on that, and that is going to be very difficult. What is an unforeseen circumstance? If a minister is in the London office and then is asked to another meeting and there's an assembly on, is that an unforeseen circumstance? And then you can participate. And it's okay to say that we can come back to it and we can change this and if there are mistakes. But let's put it this way, sir. This assembly can make decisions on legislation that can be won by one vote or lost by one vote. And if that point there is an inappropriate use of this rule, I doubt very much so, and legally I don't even think we can go back to that ruling and say, well, actually, they really shouldn't have been attending. It was a bit of a bad decision and they misused that situation, but that law has been passed. And that says nothing to the electorate on this island, and that's one of the problems that we have with this. And so I agree with Deputy. I don't think it sends out the right message. So if you work in any occupation, if you are ill, you provide sick note, you have certain time off. After a certain time, actually, you go down to half pay, but we'll go into that another time. Regardless of what your illness is. And you won't have that access that we will be given. And I think it's really important that we don't separate ourselves in that way. So I think that one of the requirements for this, if you are ill, would be some sort of sickness note, the same way that everybody else on this island has to do that when they go into their workplace. Because I'm sure that not a single member of this assembly would want to do that. However, members of this assembly will not be the same all of the time. There will be new members of this assembly. And so therefore we can't be guaranteeing that this situation won't be misused. And that's the key to this. We must stand up at some point and say we've gone far enough. So what I would suggest is that this is withdrawn for now and we have a period of normality for perhaps a year to see the effects of that, and then come back again and see whether this is actually needed significantly for this assembly for it to function. And we need to look at whether this assembly, and I'm going to say this, and this, I think I was doing so well, but let's just say this anyway. So I'm concerned that we're not giving the priority to this assembly that we should, and I understand that government is difficult, of course it is, and there are many demands made of us. But we cannot be in other areas at times of this assembly. We only sit every 3 weeks now, and we're sitting for a day at a time, a day and a bit at a time. Therefore, we should be prioritising being here. Now, sir, if there is long-term illness, as I've said, then that can be dealt with. I absolutely agree with that, but people need to be looked after, and we need to be supportive of people at that time to make sensible decisions. He says, I hope my wife's not listening because she's going to be shouting hypocrite at the radio. I'm sure that's not the case, sir. But you have to make sensible decisions about your health. And so I do not believe, and this is no criticism of PPC, because this is an almost impossible judgment to be made anyway. It's a really difficult job, this one. I recognise that. But I genuinely think we should hold fire on this. And we should step back from it, take some time for normality, and then come back to this when we've all seen that for a while. Because I think there are members from the old assembly that are fatigued by the online process and seeing the way that's happened, and looking forward, I don't want to extend that anymore. So there was one more point that was made. The notion of unforeseen circumstance. So some people may be off island more than others. They may have perhaps more holidays or family and so on and so forth. So there may be more occurrences of that. And I think that's going to be an almost impossible decision to be made by whoever's making that decision as to whether that's an unforeseen circumstance. Therefore, so I don't think we should put anybody in that position as well. So I actually urge members to reject all of this. And I would ask, perhaps, I have thought about a reference back to come back with a bit more detail as well in terms of the way this would work and much more detailed drafting of the guidance. But I'm not so sure, so I'm afraid so I cannot support this at the moment. Thank you, sir.
Deputy Taddy.
Thank you, sir. I'm happy to carry on from my former colleague. This isn't a party matter. I think this is an interesting matter that's come before us because it's we're in a position which we didn't arrive at out of choice, and I'd like to remind us of that fact. So the reason that we were allowed remote access in the first place was not out of some loftier ideal of fairness, enfranchisement or pragmatism. It was because of COVID and the restrictions that were imposed specifically because of COVID here, and we weren't the only place to do that. And it's not because we wanted to make it easier to attend, it's because we were forbidden from attending this place. And the only way that we could attend and have sittings every 2 weeks back then and every 3 weeks subsequently was so that we had a virtual way of doing that. And similarly, as things progressed, if you had COVID or if you had been in contact with somebody who had COVID, we were forbidden from coming into this place. And as we know, as things got slightly more normal, but still very bizarre, I think it was at the beginning, in fact, we were sitting at Fort Regent, spaced out. So these were very unusual times. And it wasn't because somebody sat down and said, you know what, isn't it really unfair if somebody's ill, especially if they've got a protracted illness and they're away and they could dial in, that they could speak and vote on propositions. So, of course, that doesn't mean that the debate on whether we should or should do that isn't valid. But the point is we know that we can do that. So it's a question now about whether we should be doing that. Incidentally, I understood very clearly what Deputy Ayer was talking about when he referred to a backwoodsman, a wood with wood for the trees in its spelling, because it's not the American definition. In Britain, we refer to a peer in the House of Lords who attends very rarely as a backwoodsman, for example. So I think he's saying, are we going to get to a point where through convenience or through whatever pragmatism, that we're going to go through a period of 4 years in any assembly and we don't see certain people for whatever reason? And it's entirely possible, for example, and this is what we need to grapple with, it's entirely possible that you might be caring for an elderly relative. I'm thankful that I've never had to care directly for an elderly relative, but I know how onerous that can be. And I know that there are periods of illness which are protracted, so it may not even be a member's illness directly. And it may well be that you have those caring responsibilities in perpetuity. And of course, other members of the public, of the civil service, in the private sector, might also potentially have those family situations, but they don't have the ability, and I would say the luxury or the option, because it's not necessarily a luxury to be able to look after a sick relative or a sick child. They have to find other means to do that, and depending on their work situation, they might be able to do that. I think Deputy Ward is correct, is that I see this very much as a curate's egg. Parts of it are very good, other parts of it are not very good, but one thing is for sure, I wouldn't want to eat a curate's egg, even if some parts of it are very good. And I see parts A and B are completely, I think, sensible, uncontroversial. They need to be the direction we're moving in. It's right that in an emergency situation, if there was a pandemic or a civic situation which prevented either the entirety or the majority of an assembly being able to sit, or even part of that assembly, then it's right that we have the facility in emergency situations to do it virtually. And I'm not saying never, because I have made previous speeches saying it does need to be looked into. And my concern is here, and I've been on PPC in the past, I was on it for my first 2 terms in this assembly, but I know that you can easily get stuck in a kind of bubble. So you get down a rabbit hole, if you think, and it becomes consequential. Well, we know we can do this. If we're going to do it for this, wouldn't it be nice to do it in these situations? And the problem is the exceptions often become the norm. So while I might have talked in the past about somebody sitting in a hotel room receiving treatment in Southampton who's got a lot of downtime, who could participate remotely, first of all, that is quite right. I think we probably do need to get to that point. We could also have a situation where in a long sitting, on a Thursday afternoon during a business plan, during a planning debate on the island plan. And after one day in the Assembly, you may well get a headache, you may well get a bad back, and you say, you know what, I can do this from home. I'm not going to be much fun sitting in this Assembly looking grumpy. I might as well just stay at home in my comfy armchair, and I can speak and I can vote if I want to. Now, there's a very strange part of this report, because it's saying on the one hand, the information and the fine detail will follow. So we will liaise as a committee with the bailiff and the presiding officers to find out what the rules should be, and then we'll come back to you. So we don't have that detail. But then they try and explain in the report about what the detail would look like. Well, of course, you can't explain what it's going to look like until you've had that conversation. So we're very much being asked to vote for an unknown, for a suck it and see. And there's a very strange comment in the paper, just one of them, which I'll use as an example. I think I know what it's trying to say. And it says, nor should they, so nor should a member, nor should members join remotely in order simply to vote if they would otherwise be unable to speak or contribute if entitled to do so. Well, why not? We can attend the Assembly physically and only to vote if we want to. So we can come here at 9 in the morning. We can decide that actually we've got nothing really to say. I don't need to elaborate on that. I mean, I think that's the majority do that. The majority might at any one point, I'm not criticising it, it's maybe something we could all do a little bit more. But the point is, the one thing we're paid for or expected to do under our oath is we owe the public our vote. Usually it's a pour or contre, but sometimes it's an abstention. And if we want to, we owe I think the public our intellect and our hard work. And sometimes that will mean making speeches on different propositions. So if a member wants to stay at home only to vote, I'd say that's a lot better than staying at home and not voting, isn't it? Isn't that the whole point of allowing members to participate? We're not going to expect people to have a minimum quota of words that they have to say or that they have to check in every so often. And I think this is what gets back to the really tough decision we've got in front of us, because the virtual experience, I think, worked really well. And we have to pay tribute to the GREF staff and to the presiding officers, because we showed very early on as a parliament that we can do this, and we did it as I said, in a particular set of circumstances where it was necessary. And there was also a lot of pragmatism applied. So I know when I was at home that you, sir, and other officers presiding gave a great deal of discretion, which you may not have done in the Assembly, and there was a great deal of goodwill. And I certainly know that often, actually, ironically, staying at home and listening to a debate online, you can pick up a lot more than you might in the Assembly, because there are, ironically, some distractions that happen in the Assembly. And I think that's part of the quid pro quo, is that the point I would say is not to try and bash potential members over the head who might avail themselves of this facility in the future, is to say, actually, we miss people when they're not in the Assembly. We miss being able to look across the rows at our opposition members or at our friends, and often at any one time those can be interchangeable, because it's good to look at people in the eye. It's good to look at the faces and see the expression about whether your comments are connecting. And you simply can't do that when it's online. And so I think that Deputy Ward is correct, that when I hear PPC saying we're going to monitor this for a year and see if it works, well, you don't need to monitor it for a period of time. We know it works. We know exactly how it works. What we don't know, and what we're starting to forget, is how normality works. We're forgetting how it works for all of us to be in the Assembly at one time, apart from those who are excusés or absent de l'île or ill. But we have had many sittings in the last 20 years, I'm sure, 15 years that I can remember, where we've got a completely full Assembly, and on some occasions you get a 49-0 vote. And we know that there's lots of consensus when we need in this Assembly. My concern is today that will be a thing of the past, and that we won't have any more sittings that aren't hybrid. So by all means, I would implore members to vote for parts A and B. I'm still considering whether there are grounds for a reference back. I think there are. I think because we don't have the fine detail about how Part C will be applied. But I would strongly encourage the chair of PPC, who may have her own doubts about this, what she's putting forward on behalf of the committee, and I'd like to hear from other committee members, because I think we're sleepwalking into a situation where we're going to be in perpetual virtual sittings. And I don't think at this point in time, after what we've been through in the last 4 years, that that's the healthiest position to be in. Finally, if it's about getting us into the 21st century, and I won't point out the fact that my deputy colleague from St Brelard isn't in the Assembly, but she did make the point that she wants to drag us into the 21st century. Well, I look forward to her making that point in future constitutional debates, sir, but I'll see how that works.
David Renouf.
Thank you, sir. It does seem that we're making quite heavy weather here of something that to me feels perhaps of less dramatic import than some people have been trying to draw out. And it is a pleasure actually to agree with my St Brelard colleague, Deputy Scott, on this. And I'm very sorry to disagree with my other deputy, St Brelard, from St Brelard, Deputy Tadia, and indeed Deputy Ward and Deputy Ayer. I think there's a real danger of confusing issues here. Of course it's our priority to be in the Assembly. Of course it's our priority to be accountable to the electorate. Of course we take that seriously. And looking around this Assembly, I don't see any sign of anyone who doesn't. I think we share that seriousness of purpose. But this is about the means to deliver that end. Our oath says, as Deputy Ayer reminds us, you will attend the meetings of the states whenever you are called upon to do so. The question is how you attend. This is the 21st century, and it is possible to attend a meeting remotely. We all do it pretty well, pretty regularly, I would suggest. The other point I would make is that no one is being pressured to use these arrangements. They are in place as an enabling option. The Deputy Ward referred to the unpleasant circumstances of sitting at home and so on. Well, as I say, that is not something that is compulsory under these rules, these changes. It is an option that is extended in fairly clear situations. And the fact that an option exists does not mean that it must be used. And personally, I trust the intelligence of members in this Assembly to make that distinction, to understand if they are likely to be harming their health by doing so. It's not something that people are likely to do on a regular basis. The point about the other point I would make is that there is actually some fairly clear guidance around this, particularly with regard to the unforeseen circumstances clause, which is the one that seems to be attracting the most opposition. So the guidance, which is here in the report, Appendix 1, unforeseen circumstances include the following scenarios: weather conditions impact upon travel arrangements and returning to the island. Public health guidance prevents the member concerned from travelling back to the island when initially planned. These are fairly clearly described limitations. It is not, as I think there is been a tendency to suggest that the floodgates are going to be opened and suddenly there will be loads of different circumstances under which people will find an excuse not to be in the Assembly. I think these are guidance written by the bailiff, and I'm sure that the bailiff will have reason to comment on them, to judge on them should that be necessary, to make a judgment about whether or not the circumstances have been reached. So to me, this feels like a measured, proportionate response to this fact that technologically we are now able to do things that we were not able to do in the past, that is a opportunity that we should take advantage of, but only in the limited circumstances which have been set out by PPC. It's an enabling option, not a compulsory option, and therefore I have no problem in supporting it. Thank you.
Very much, Deputy Frame.
Thank you, sir. As states members, we're not employees. But if we were employees, we would have the right to ask for flexible working. That right was introduced a number of years ago and initially applied to anyone who had caring responsibilities, but was later extended to include anyone. So any employee in Jersey has the right to ask for flexible working. Of course, the employer has the right to refuse, but has to give good reason. Now, sir, whilst we are not employees, this is a workplace. And I think it's entirely reasonable that anyone who has caring responsibilities, either for a child or for an elderly person or somebody with a disability, that they have that right to be able to continue to attend the workplace, which is here, and carry out their duties at home. Because how do we attract a more diverse member to the States? We've just seen in the last election, we've had better diversity in this Assembly than ever before. How do we continue along that path? We make sure that people can attend and can still live the life that they've got. We remove obstacles by allowing this to continue. So, in relation to remote participation for health reasons, I would certainly be supporting that. I think most people, if they've got any sort of thoughts against this proposition, they're more concerned about the remote participation whilst outside of Jersey. And if that's the case, then let's not throw the baby out with the bathwater. Let's go ahead with parts A, B and C, allow the Assembly to continue to be inclusive. If members think that participation outside Jersey is a step too far, then that's fine. We'll see how that vote goes. But if it is split into two votes, I urge members to support the first part, because that's the way we're going to continue on the right path in this Assembly. Thank you, sir.
Very much. Deputy Felton.
Thank you, sir. I think it's important to keep in mind that PPC brought this proposition in answer to two propositions that were passed by the previous States Assembly. It's within that spirit that PPC has brought this particular proposition forward. Talking individually, I do have difficulties with certain parts of this proposition. Part 1, A and B, does seem to be very sensible and enabled to give the bailiff the tools that he would need in certain circumstances. Part C of that, I have to admit currently, and it's not very often, I'm actually sat on the fence with that. The reason being that I do value that we have a diverse Assembly. However, when I think back to my working career in the civil service and as a union rep, I am aware that the majority of our employees within the public sector can't work from home in those circumstances. And what concerns me is how those people may feel when we're giving ourselves flexibility that they themselves don't have, particularly given their very restrained periods of annual leave. So I don't think, in all honesty, with all good intention, I could vote in favour of a position for myself, which is very much favourable to all of those public sector workers, compared to those public sector workers. Part B, I have to say, I do struggle with thinking through the risks of it. I know in the past, probably presently and in the future, there have been and will be members that do have second homes, for example, and spend an awful lot of time outside of the island. Currently, with the current standing orders, they may be less tempted to spend so much time out of the island on the basis that they have to ensure that they are back in the chamber for a sitting. However, should it be passed today, they may be more inclined to spend more time out of the island, come back at the last possible flight just before a sitting, and if they happen to be fogged out of the island, that's okay, they can attend remotely. And I do think that that is a real risk, that we could be inviting the type of states member that actually doesn't reside on island and spends as little time as possible on island, when actually I am a firm belief that all of our members should be primarily resident on the island. So those are my concerns with this proposition. I am a member of PPC, and I know that we all do have differing views on these matters, but I do thank the chair of PPC for bringing this proposition forward, because it is what we needed to do in response to those previous propositions. Thank you.
Thank you very much, Deputy. Alex Curtis.
Thank you, sir. And I don't have too much to add to other speakers, particularly those being Deputy Rob Ward and Deputy Tadier. I'm concerned that I'm being told I'm living in the 20th century, given that at that point in time I wouldn't be old enough to stand for this position of office. But attending the States in person was a commitment I knew when I stood up for the job. Or not for the job, for the office. Deputy Ferry, who's gone unfortunately, says we are not employees, but employees would get a right to flexible working. Well, we are office holders, and we sign up to responsibilities. A director of a company commits to attending few board meetings, but commits sincerely. They do not take flexible working into account, that they have 12 meetings a year potentially. We meet once every 3 weeks, and our commitment towards this assembly may be different to the commitment we hold to regular meetings with officers. Deputy Reniff does say that we join meetings remotely often, and as I say, that is true. But I think in important matters, it is still, where possible, important that we meet people face to face. I do have remote meetings with regular officers who I work with, but even when it's a meeting with an officer or member of the public who I don't know, I think it's really important that I show up as myself and I am present for them. The States Assembly, I think, sits at the highest of those regards. What else can I say on this, really? I'm not comfortable with the ambiguity around this, the fact that we have a whole set of circumstances around unforeseen, what we consider a medical reason, that would be agreed by PPC and the bailiff. I would like to see that as a schedule or something far clearer. And the mention of a reference back was mentioned, but I actually would agree with Deputy Rob Ward on this. Let's give ourselves 12 months. Many of us have been excused roll call for medical appointment, myself included, which may be connected with being unwell. But as of today, we attend that medical appointment, and if we are fit to return to the Assembly, we return to this Assembly. If we are not fit to, we don't. And really, to Deputy Rob Ward's comments again, I think he makes it really well that if you are sufficiently unwell, or you are sufficiently committed to the health and well-being of your family members, then your attention should be on them. This is not a place where we are really, owing to that idea that we could almost hear for, the call for the appel and I'll take votes. I think we really do need to place our focus on being in the States Assembly first and foremost. And we wouldn't want to get to the point where a significant, the recourse of inebriation the night before would be sufficiently unwell for you to work from home, shall I say. And I don't say that lightly, that there is always a slippery slope on what we consider our responsibility to be in this Assembly as. First, it becomes actually, it works quite well when you're not here. Well, I think we really need to make sure that we are committed to testing and trying our obligations to being here, being in person and being present. I'm really glad that Deputy Scott has joined about the 21st century comment. Deputy Tadier made a call on constitutional reform. I will make a call that I hope soon we will debate what I think will be the 21st century, which is, my last employer had a slogan which was, come as you are, do what you love. I am not in the clothes that I love, and I am not coming as I am right now, so I look forward to support likewise in any changes to standing orders about dress code.
Before I call upon the next speaker, I should perhaps clarify, I think that in terms of the way the regulations are put, Regulation 1 and Regulation 2 can be voted on separately, but not the subparagraphs within the regulations. Very well.
Can I just seek clarification? So that means, effectively, what we're having the contentious debate about members being able to dial in ordinarily for non-emergency, a non-state emergency is contained in paragraph 1. So we can't disentangle that. Is that correct?
I think the way it's drafted, it can't be disentangled. I have considered it and discussed it with the greffier. And
So
I think
with
it's-
that in mind, is it in order for me then to ask for a reference back? Because I believe that and it would be
Well,
to
just
seek more information.
Before you do that, yes, the answer is a member may, whether they've spoken or not, at any time seek a reference back. A reference back is to provide further information or seek further information. You'd need to specify what the information is, and the debate would continue on whether or not there would be a reference back. But the Connétable St Martin has an intervention.
I'd just like to clarify to the Assembly, if I may, before a reference back is given or asked for, that getting rid of this amendment will not get rid of remote participation. The status quo will be maintained where there is a scheme with no parameters and people will be able to request the link for whatever reason they like. This is PPC actually trying to...
No, I understand,
Yes.
and perhaps what you're explaining, if I'm correct, Connétable, is that at the moment the Assembly is not in a position where there is no remote participation. It's in a position where there is remote participation, and this is changing the parameters slightly of that remote participation. So, Deputy, as I indicated, Deputy Dallier, you're entitled to ask for a reference back. You don't have to do it now. You can do it in just a moment. Deputy Doublé.
Thank you, sir. And some of the points I was going to make were made by my St Saviour colleague to the right here, and I thank him for that. And before I get to the main part of my speech, I wanted to refer to the previous speaker. And I really do take issue with some of the points made. And quite often, those of us who do have caring responsibilities, those caring responsibilities are conflated with a lack of commitment. And I find that quite offensive, and I don't think that's something that we should be furthering in this Assembly, because often those with caring responsibilities are working very, very hard and juggling multiple responsibilities, and also bring a perspective of those members of the public who also have caring responsibilities, and we represent those views and those interests and do the very best that we can. So that conflation of lack of commitment needs to be put to rest. And also, just to challenge the fact that you can make a commitment, any one of us at any point could suffer an accident and be subsequently disabled with a physical disability that might mean that we are completely able to participate mentally but physically not able to reach the chamber, which we know is very old and not built with for those with physical disabilities. And this remote participation would enable those of us who had committed to this role to carry on to the fullest extent possible and see that commitment through. Equally, any one of us, perhaps of childbearing age or who are partnered with those of childbearing age, could become parents and need to attend to those responsibilities. So what I wanted to remind members of are some basic principles, because the Environment Minister said that we are at risk of making heavy weather of this. And he's right, but also I think we're at risk of forgetting some of those really fundamental principles that I really believe as an Assembly that we're more united on than any Assembly ever has been in the past. And that is the importance of the diversity of this Assembly. And looking around the Assembly, we are the most diverse Assembly that we've ever had. But diversity, whilst it's very important, it's not the only important principle. There are groups of people in society who are marginalised and therefore do not commonly hold positions of power and have to work extra hard to gain those positions of power. And once they have them, if they are not fully included, if we don't have inclusion, then actually that diversity doesn't mean anything. So it's our duty as a diverse Assembly to make sure that our practices as a group are inclusive of everybody. And the chair of PPC, she just gave a really important clarification, is that we already have remote participation and we've had it since the start of COVID, and I don't feel that we have been in an emergency situation for several months, yet we've still been able to use it. I do not see that it has been widely abused by members. I think it has been largely self-policing, and I think, you know, we could argue that actually we don't need any guidance and that we police each other and that we hold each other accountable. But the Constable of St Martin has gone one step further with her committee, with PPC, and has put some very reasonable a reasonable framework around it. And I think it does make sense. I did have to pause for some of it, and that was the unforeseen circumstances, which is the final part of it. I'm not going to speak to that just yet, but I want to focus on those first three. I think it's ABC, part one, which I think we've just been told that we have to vote on that together, if I understood that correctly. And I can't stress enough, Sir, how important it is that we do vote this through today. Not just because it doesn't make the situation any worse, it just adds some safeguards, but also we do have a duty to make accommodations to enable the full democratic participation. So it's not just about diversity and inclusion, this is about our democracy. If somebody is elected to this assembly, we have a responsibility to help enable their full democratic participation in the work of this assembly. And that includes people with serious and chronic health issues and disabilities, those going through normal biological processes like pregnancy, breastfeeding, and those who for a period of time have to care for those, an infant or otherwise, who are dependent on them. It's not actually that difficult, and I hope that we can agree on this today. So I am somebody who's been in a position where I was about to have caring responsibilities for an infant, and there was nothing. There was no guidelines, there was nothing in standing orders. I was only the second woman ever to give birth whilst in office. And PPC at the time were tasked with bringing forward a change to standing orders that would give me that would instruct me on how I should proceed, because the baby was coming, whether I liked it or not. And actually, that was not put in place in time for me to give birth to my child. And the reason for that was that there was too much debate about the best way to do it, and who do we include, and should we include adoptive parents, and should it be a secret or not a secret, and should we declare it? And there was so much debate about it and worry about it not being a perfect solution that it wasn't ready in time. And I think we have to stop striving for perfection and approve this today. And I think there is a very reasonable mechanism within there, which is the guidelines. And I've looked at the guidance, and actually I think a lot of the things that we're discussing have already been considered by PPC, and the answers are actually in there, and it looks reasonable to me. I don't see any reason why, for that first part, A, B, and C, that we shouldn't approve that today. Please don't let's go back and make things worse in terms of inclusion. Let's move forwards. If there are issues and members feel strongly that something should be in the guidance, then I'm sure they can make representations to PPC and to the bailiff. And we know, Sir, that you are very good at keeping us in order and making sure that we stick to the rules. That's part of your job. And also, the other thing that I just wanted to mention, in terms of infection control, what have we learnt from COVID? Just because it's not an emergency, do we really want somebody who, say, perhaps has a stomach bug and might still be infectious or has had flu, do we want them sat next to us in this assembly because they're desperate to vote on something that's important to them? Or should they be actually at home? I can see Assistant Health Ministers nodding at me. Should they be at home participating remotely and not making us all ill so that we then aren't able to serve our constituents? So that's just a small add-on to my speech. So please, Sir, I urge members to vote for the first part of this. I'm not actually going to speak on the other part because I think there are other people that might have more to add than myself.
Thank you very much, Deputy.
Thanks, Sarah. Could I raise the standing order, the matter of Standing Order 83 and propose a reference back? And I'm happy to elucidate the grounds for that.
Yes, you're proposing a reference back. Firstly, you have to identify, Deputy, what information you are seeking or what ambiguity you're seeking to address. Secondly, I have to ask whether or not it is seconded before you make the proposal. Then the debate can only be on the merits or otherwise of a reference back until the Assembly has decided whether there is to be a reference back. We can't move into the other general...
Can I second the proposition, sir?
Well, you're very well. Well, then it is seconded. So what is the information you're seeking, Deputy?
So I'm seeking specifically what is referred to in part 2, 2A and the second part 2B, which says that following consultation with yourself, sir, that Privileges and Procedures must issue guidance on the interpretation of paragraph 1C, and it says something similar for paragraph 2B. And what I would like to know before we debate on this and when it is brought back, that we actually have that piece of work done first so that we can see what the guidance is that goes hand in hand, so we actually know what we are voting for. That's what I would ask the information is, sir. We clearly don't have that information yet because it can only be produced in consultation with PPC and yourself, sir. So whilst there might be some notes and suggestions of what that would entail in the report, that is the specific information.
Well, I will give you the chance to recast that slightly, Deputy, because the guidance that's in the proposition is guidance that I've already considered and discussed with PPC. It is the draft guidance. Nothing more can be forthcoming than is there at the moment. So it's a question of is there further information that you're seeking?
So I think that is, we want to know exactly how this will be implemented. So following this debate, if it were to be passed today, I don't think we have that information categorically about how it would be, because it says it needs to be done in consultation. So if I can add, and of course this isn't information, but what it would also allow is for PPC to take into consideration all the comments that have been made in this. And something that's quite fundamentally would be a positive byproduct of this reference back, although not the basis for it, is that PPC would then be able to reconstitute the paragraphs of the proposition to allow members to actually vote for and against the emergency parts and differently on the subsequent paragraphs if they so wish to do, which they can't today. But that's not the, that's simply a byproduct, sir.
Very well, but the information you are seeking is further information on how this will in effect be implemented. Very well, it is... so do you wish to go any further than that in the proposition at this point? Deputy Luce, you have indicated you're prepared to second that?
I am, sir.
Very well. Then does any member wish to speak on the question of the reference back? Deputy Reniff.
Yes, sir, thank you. It seems to me that this reference back is based on a simple misunderstanding, which is the appendix very clearly does answer the questions that have been raised. And I think that the guidance is already there, it's in existence, and we're being asked for something that you have already made very clear has been done, and nothing further can be added. So it feels to me like an attempt to refer back something with which certain members are not happy, but the standing order test feels to me to have been very close to not being met.
Deputy Miles.
Sorry, sir, that was a mistake.
Deputy Luce.
Thank you, sir. And of course, I wasn't expecting to speak in a reference back, but what I would say to members is in this instance that I think we need more clarity around the member of a household and what exactly that means, and whether that would allow me, if somebody who lived in my household was ill on holiday, to remain with them, even if they sprained an ankle or what have you. I think there's a lot of opportunity here. So the phrase I was going to use if I'd spoken in the main debate was thin end of the wedge. And I am hugely concerned that parts A, B and C of one need really to be split up, because I'm absolutely content with A. I'm a little bit less content with B, but not happy about C. I was hoping the reference back may well have included the separation of those, but I will certainly support Deputy Ward, Deputy Iyer, Deputy Taddeo. I think we need to think a little bit more carefully about this. I know members will say, oh, PPC have thought carefully, but for me it's a great concern, sir.
Very much, Deputy Scott.
Thank you, sir. I just was, again, unclear about exactly what the reference back was looking for in addition to Appendix 1. So it's still unclear to me, so I don't really feel I can support this. What I will just mention, though, is that in terms of things like the possibility that somebody might be abusing, and I think this whole kind of debate as we're having is about the extent to which states members may abuse power. We're getting to the point of detail where I might say, well, why don't we extend this to the amount of times that people leave the chamber whilst they're debating, sitting in the common room, talking, not listening to the debate? Maybe that's not acceptable. Or when they nip over the road and maybe disappear.
Deputy, I think you're straying off the value or otherwise of a reference back, which
thank you,
which
sir.
I have to limit you to in accordance with standing orders.
Thank you, sir.
Any other member wish to speak on the matter of a reference back? No other member wishes to speak. Deputy Coles.
Yes, thank you, sir. Sorry, I'm just going to be quick for this. There's the points about what the list entails, and there's the comment on that it's not possible to list exhaustively all health-related issues, but there's only 3 items that are mentioned within the appendix when it comes to health, which includes quarantine for self-isolation, preparations for surgical or medical procedures, and where someone in the member's family or household is ill. So I think there could be more added to that of what either is appropriate and what isn't, what is inappropriate as well. As Deputy Curtis referenced to, if someone had a little bit over intoxication one evening, maybe from a sampling, that maybe somebody would deem that was a reason to participate online. So I do believe a reference back should be brought, and a slightly more extensive list, but obviously I appreciate the list can't be exhausted, but I think more than 3 points should be brought towards us to agree or disagree upon.
Any other member wish to speak on the question of a reference back? Deputy Rob Ward.
Thank you, sir. Sorry, sir, Deputy Mesic will have to sit in the Dean's chair. He might get to like it. The point that troubles me most, and I think we've missed some points in the debate, but anyway, the point that troubles me most is the remote participation whilst outside Jersey and the information there, because it does talk about in unforeseen circumstances, and then it says unforeseen circumstances include the following. It doesn't say what it doesn't include, and I think we could be listing things that are not included. So, for example, if members go off on state's business and plan to come back at 7 o'clock in the morning on the day of the State's Assembly, or they go on holiday, I think that's not good planning for them. And so that could happen again and again. But to better explain my concern, and so that's part of the issue. There are concerns here that is very difficult to explain because it's quite difficult to understand what this will mean in practice. And I think that is the clue as to why we need a reference back in a bit more detail. And I understand guidance. There is this guidance, but that is a very open guidance. In unforeseen circumstances, in public health, I get that, but if we allow a generic term like unforeseen circumstances to go ahead without some very tight parameters within which we're working, they can be stretched and stretched and stretched, sir. We have seen examples in this assembly in the past where so people are off island, what are they off island for? It's family. Is it urgent family? Oh, yes, it is. Now, okay, but there's no... It sometimes does not help our image with the public to be excusing people in that way without some detail in what we're doing. And the unforeseen circumstances phrase in this will allow, I believe, and this is my concern and why I want this to come back to us with a lot more detail in terms of what that means, it will allow ministers to be in the UK between two what would be considered as important meetings and attend online. And there is nothing in here that says that will not happen. And sir, I believe, and I believe many members of this assembly would say that is not the right way for us to proceed, because you need to be here. We are not running this assembly remotely off of this island. And I think the thin end of the wedge, the argument is a very strong one, actually. And this is where we'll end up if we're not careful. And that is why we need a lot more detail in the guidance. Some scenarios, for example, the scenario mentioned there by Deputy Luce was an important one. What does it mean in terms of who's off sick in the family? And there's also a very important point earlier on that says, and it's something I mentioned, it's very difficult to see this because again it's prose rather than points, about the members participate remotely. Sorry, sir, just give me one moment. About their well-being. It says something about taking into account their well-being as well. I can't find a phrase now. I wasn't ready to speak on a reference back. It was quite obvious. But there's something about members' well-being, so, and I think we need to be much more precise in that. Nobody is stopping. I do not want to stop inclusion in this assembly. But the other end of that scale is, sir, it could stop us making this assembly more inclusive if we don't have some parameters. So, for example, where there's a scenario that these guidance does not cover, if somebody is elected with a physical disability and cannot access assembly, does that mean they're constantly attending offline because we've got a facility for them to do that, and so therefore we don't have to change anything else? That's the sort of guidance that we'd have to see. In any workplace, sir, you'd have to make reasonable adjustments to your workplace so that people can be involved fully. This could be a recipe for us not doing that. And within this guidance, it doesn't address those issues. I just think we need a lot more guidance before I could vote on this. Otherwise, sir, I think we cannot vote on this. Thank you, sir.
Deputy Morell.
Thank you, sir. I'd like to speak in favour of the reference back because I think we've already heard enough, to be honest, to tell you about the confusion that there exists around this proposition to warrant a reference back. I personally have my own lack of understanding around it in that we have been told that this is to put parameters around a situation whereby basically the greffier is required to pass on links for remote participation to anyone who requests it. Yet when I read Standing Order 55A, it starts with number 1 saying this standing order applies during the period of a state of emergency as defined by the Emergency Powers and Planning Law 1990 and at any other time when the bailiff considers that it might not be possible to convene or maintain a quorum meeting of the States in view of substantial risk to the health of members of the States or any other person. So there are parameters, in my view, already around that. And I don't understand where this idea that there is this freedom for the greffier to just hand out links on request comes from. And I am absolutely always more than happy to be corrected. The point I am trying to make is that we have not had, and I have just confirmed, there has been no consultation or briefing to States members on this proposition in advance. And I think that would be really, really helpful so that we could ask the questions that we'd all like to ask. Because, I am basically against part 2, but I could be won over if I really understood the need and understood how strong those parameters are. I think Deputy Ward has just outlined why even the guidance that's there in the report for this proposition, has its own ambiguity straight away. And I can see, oh, well, it wasn't weather, sir, it was mechanical problems with the plane. Well, I can promise you, sir, that's the first thing that's going to be thrown at you or whoever's the presiding officer when these unexpected or unforeseen circumstances are brought forth. So I think a reference back is really necessary. I think PPC need to speak to States members, not just bring propositions without speaking to States members first, help us understand what it is that's being the problem that's trying to be solved, and then we would all probably be much more willing to press pause and move on, because as again, sir, the irony hasn't passed me by that whilst we have voted on probate, which is about people's, estates after they've passed their last will and testament, those sorts of things, and we've voted on the Children's Commission, we voted on various other really important matters today. The one we actually talk about is ourselves, as usual, sir, and I think we could avoid talking about ourselves if we had that consultation, that briefing first, sir. Thank you.
Constable St Martin.
Thank you, sir. What is disappointing about the reference back is that members are worried about not having parameters or the correct parameters at the moment. But at the moment, we have no parameters, and this amendment gives the parameters. We cannot list every medical condition and every scenario. Or I suppose we could attach a medical dictionary, you know, I'm being a bit flippant here, but we could attach, you know, every medical condition, because nobody knows what anybody in here will end up with. And we can't, you know, we can't list every scenario. And I was hoping that, you know, common sense would prevail. And then we keep hearing about unforeseen circumstances. And I'd just like to say that by definition, unforeseen circumstances can be very hard to predict. Thank you, sir.
Does any other member wish to speak on the question of the reference back? Right up, St Mary.
Thank you, sir. Had I spoken earlier, I would have followed the Environment Minister's comment that we're making a meal of it. And in fact, my own case, it would. I've been in situations post-COVID where I was able to participate in a debate when I was at home because I was mentally okay, but not physically able to travel here. And by not having that facility, it does encourage members to come in when they're ill and pass on their disease to everyone else. But I am now in favour of reference back, if only to enable us to consider one point, which is at the moment, this Assembly is in charge as to whether we allow a member to participate or is excused. And back to people planning holidays and coming in at the 11th hour, there have been some grudging acceptances of that in the past, and ministers, I think, have learnt the lesson and plan more wisely in the future. And I simply wonder whether a reference back would enable us to put some control on the part of states members to sanction such a thing. So for that reason, I will support a reference back.
Deputy Curtis.
Thank you, sir, and I'll be really quick because we are making a meal of this. I would urge members who want to support or vote against at the moment to support a reference back. I like to think I'm a pragmatic man. I have a set of principles as to about how the states should sit, but I am more than willing to listen to exceptional circumstances and how we find a pragmatic way forward. I do not find confidence in the current draft and the annex, so I would say a reference back would be a way for those who do want to see a level of change to actually enable that.
Does any other member wish to speak on the reference back? Close the debate. And Deputy Taddy.
Thanks, sir. Thank you. I think we heard from a good cross-section of members there, and I think we've heard enough to assure ourselves that the guidance, first of all, hasn't been written. We're asking for guidance to come forward following this debate, whether it happens now or not. And what I'm asking for, and I think what many members are asking for also, is that we do have more clarity about what the guidance will actually be. So this is a call to put more meat on the bones. Not so much to talk about the medical dictionary of different conditions, but to talk about how unforeseen circumstances might be defined. And I think very much thinking of Deputy Luce's comment about the thin end of the wedge, rather to think about what the unintended consequences might be if we pass this today. We might pass it in haste but repent at our leisure. I would simply say there isn't going to be a void or vacuum here. We already have a scenario where people who are ill can join virtually. So if you do have the aforementioned tummy bug, or if you have a heavy cold and you don't want to spread your germs, members can already attend, and they will be able to do that in the interim. But what it does allow PPC to do, and I would emphasise that I think PPC is probably a microcosm of this Assembly, because they have, I think, split in differing views that we may not have been, and we may not have been party to all of their deliberations. I think we can come back with a better proposition, slightly with more information about the guidance, and maybe in a different format, which could see a much, if not a completely unanimous vote, certainly one with much more consensus, which is more befitting to, I think, what we're trying to do today.
Thank you very much. Do you call for the appel? Well, the appel is called for. I invite members to return to their seats. The vote is on whether or not this matter should be referred back for further information as to how it would be implemented if adopted. I ask the greffier to open the voting. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. The the reference back has been adopted. 26 votes pour, 16 votes contre, 2 abstentions.
Could we have the 16, please, and the 2?
Those voting contre, the Connotables of St Clement, Grouville and St Juan, Deputies Doublé, Gorst, Farnham, Moore, Miles, Scott, Renouf, Rose Binet, Jearn, Howell, Tom Binet, Ferry and Stevenson, and those abstaining with the Connotable of St Martin and Deputy Kovac.
Very well, that concludes public business, and I move on to arrangements. Just right. I ask the Chair of PPC to propose the arrangement of public business.
Thank you, sir. The arrangements of public business for 13th June 2023. Presently, we have 8 items listed for the state sitting on the 13th of June. Please keep aside Tuesday 13th and Wednesday 14th June, and be aware, as usual, that the states may run on to 3 or 4 days, although at the moment I do not anticipate this. Thank you, sir.
Before adjourning, could I ask members if they would return at 5:15 in the chamber? Watching everyone has been Jennifer Long, who is the State Remuneration Reviewer, and she is going to, I believe, make a presentation at 5:15. And we'll take questions from members. It's not anticipated, I think, that it would take longer than an hour for the entirety of it, but if members could come back, it was originally scheduled for 6, but as we finished rather early, it might be more appropriate if members could be in the chamber at 5:15 for that purpose. Very well, the business of the Assembly is concluded, and the state stands adjourned until the 13th of June.